Hey everyone! I want to thank those of you who are watching my LinkedIn videos, especially those of you who are liking them and commenting them. So this video is actually in response to a recent comment by Tommy Martin, hey Tommy, about the unregistered solicitors. So one of the criticisms was that the case study I post about, the individual only faced a $1,000 fine. So I agree it's not a huge monetary damage that he had to pay. But he was also an attorney, so there were, certain bar issues he could have faced as a result of those transactions. But I want to give you a better case study that really illustrates the potential monetary fines you can face. So one of those is an SEC action, happened on March 8th, 2013, and involved William M. Stevens, an independent consultant who was soliciting on behalf of Ranieri Partners, LLC. So Mr. Phillips, he received transaction-based compensation for his services. And it wasn't just about going and finding clients and telling them about Ranieri Partners and their services. This person in particular sent PPMs, subdocs, due diligence materials. He urged at least one investor to consider reallocating certain securities in his portfolio so that they could invest in the Ranieri Partners fund. He provided potential investors with confidential information relating the strategy of the fund and the track record and identity. He also provided the identity of other investors and their capital commitments. So in this case, the SEC said he was an unregistered broker. So for those of you who are duly registered as RIAs and doing business with a broker-dealer, this is something that's especially poignant because it can be applicable to you. So ultimately, what penalty did these folks face? So for Ranieri Partners, they agreed to pay a penalty of $375,000. Mr. Phillips, the solicitor, agreed to pay a penalty of $75,000 and was barred from the securities industry. That's a pretty significant disciplinary action. To be barred from the securities industry, you have ruined your career. You are never, ever doing any sort of investment activity again. So that's pretty significant. So the SEC also suspended Mr. Phillips from acting in a supervisory capacity as an investment advisor or a broker-dealer for 9 months. So, the bar, I would think, is a little bit more significant. But you can face a really huge penalty. And for an individual to pay $75,000 and then be barred from the industry, you've wiped out your career, you wiped out your ability to make a living, you've ruined your lifestyle, you've ruined your business. And for what? For not properly registering either as a broker or as an investment advisor representative because you're soliciting on behalf of an entity. So the other kind of criticism that Mr. Tommy Martin posted was that I didn't address the fact that advisors don't want to have to tell a potential client that they are paying someone to bring in clients. And in my opinion, you may feel that way, but you have to, because then you just face the possibility of ruining your life, ruining your family's life, facing these kind of severe penalties. And really, in my opinion, it just comes down to mindset. If a potential client is hesitant about becoming your client because of an arrangement you have with someone who's essentially marketing your services and bringing clients to you, then they're probably going to have a lot of issues with a lot of the way you conduct your business otherwise, outside of just having a solicitor. And this could potentially be a person that could cause you headaches and issues down the road. So I see the requirement to disclose these arrangements as part of your vetting process to find clients who are going to understand the business behind providing financial advice and understand that a solicitor is much like a salesperson or a marketing person that's going out and bringing really great clients to a wonderful advisory firm, and that you're trying to reach as many people as you can to help them and to help them plan their future and the future of their families, and to be able to provide the lifestyle they've gotten used to. So I don't think it's a bad thing. I think it's a way to vet potential clients. You want to weed out the people who are going to complain about how you conduct your business. And if one of the issues they have is that you have essentially a salesperson or a marketing person going and getting you clients so you can help as many people as possible, then you really don't need that person as a client. So I think it serves your business, and I also do believe it serves individual investor to have this requirement to disclose these kind of arrangements, to have to get registered if the state requires it. Even if they don't require the registration, of course, still you're required to disclose these kind of arrangements and the compensation that person's receiving. And that solicitor has to provide the potential client a copy of your Form ADV brochure. So I think these are all really great things, and it just comes down to have the abundance mindset. If someone comes in and they're put off by the fact that you've used a solicitor and you're compensating them for bringing in clients, it's okay. That person's probably not going to be a good client for you anyway. Have the abundance mentality. There are tons of potential clients out there. There are not a whole lot of advisory firms. If you think of all the advisory firms that are registered in the country, there's only a small percentage that really uses solicitors. So think of this as the abundance mindset. There are a whole bunch of potential clients out there. Your solicitors are going to bring the right types of people in because they're going to be excited by the fact that you have a business model that's trying to go out and reach as many people as possible. So Tommy, I hope that answers your question satisfactorily, and I hope the case study also illustrates to all of you that on one end of the spectrum, yeah, you have the $1,000 fine with the state of Texas. On the other side of the spectrum, you have a bar from the securities industry, a $75,000 fine personally, and a $375,000 fine for the firm. And so you can really face a lot of issues. Now, the difference between the two is that on one side, you had 3 clients over a period of over 10 years, versus on the other side of the spectrum where we had much higher fines and a bar from the industry, you had someone who was much more involved and was providing more documents and had a higher number of potential clients they were targeting. So if you have any more questions, let me know. I want to address them, and I'm going to do these videos to address them. So comment on this video or the original video. I love hearing from you guys. Thank you so much for commenting and following, and stay tuned. This coming week we'll have another episode. Until then, enjoy today, Sunday, the day of rest. Enjoy your families. Enjoy the fruit of your hard work, and we will see you in the next business week. Thanks.